Hi, welcome to MJT Law. My name is Melanie Thorley and I'm the Principal Solicitor here. What we do at MJT Law is provide employment law advice. That could be anything from beginning of employment, contracts, getting your policies right, figuring out which business structure is the right one in terms of do you want contractors, employees who are part-time, full-time, casual, right all the way down to what we call the back end or downstream, which is all that litigation, all that scary stuff. But we're going to stick to that front end stuff so you don't have to get to the scary stuff. Today we're going to be doing a masterclass on a bunch of topics. We're going to be doing them on payslips, how to dismiss an employee as a small business, employee grievances, drafting employment contracts, employment commissions, tribunals and court claims, policies and procedures, and restraints of trade and confidentiality. All of this is going to help you understand how to deal with your employees better, to get it more right more often. We all know that this stuff is really difficult. We all know that employment law changes, and what we want to know is how to get it more right more often. And we think at MJT Law we can do that for you. We can help you out there. Now, once you've watched these courses, if you've got any questions, just let us know. We have a whole team here that can help you, and we're really good at this stuff. So enjoy the classes, and perhaps we'll talk to you soon. Today we are looking at what's on a payslip. Now I'm going to use Google to help us because Google is awesome. And I'm just going to put FWO for Fair Work Ombudsman, and I'm going to put what is on a payslip. No, not pay. Okay, what's on a payslip? Okay, so there's an awful lot of stuff going around about what should and shouldn't be on payslips. So the Fair Work Ombudsman has given us some guidance here, and we're just going to have a look at that. Payslips should cover the details of the employee's pay for each pay period. It's also a breach of the Fair Work Act to not receive a payslip. So your employer might have them on some sort of online website that or intranet that you can draw them out of, or they might give you them in hand. But it is not lawful for your employer just to pay you and not provide a payslip whatsoever. So it is, and it's really important that you receive them. So the employer's and employee's name, so your employer's name and your name should be on it. The ABN, if applicable, any pay period, the date of the payment, the date that you're going to receive the payment, the gross and net pay, and if that confuses you, gross pay is your total pay without the tax being taken out, and your net pay is the amount of money you're going to receive into your bank account after all the tax is taken out. Okay, so gross pay is all the monies, and the net pay is the monies without the tax. Okay, and if the employer's paid an hourly rate, what that hourly rate is, the number of hours that you worked, and the total dollar amount of that hourly rate. Okay, and then it talks about loadings. So we're talking about casual loadings should be on there, allowances, bonuses, incentive-based payments, other paid entitlements. They all should be separated out in your payslip. Okay, so it says here, for example, a note could be included on a payslip that an hourly rate incorporates the relevant casual loading. It's actually new, and it's new from this year because of a decision that came down, but it's good to see that they've updated their website. Okay, the pay rate that applied on the last day of employment as well. So if this is your last payslip, then there should be some information there too. And any deductions from the pay, including tax and superannuation. Yeah. Now, superannuation contributions should be on there also, and all the amounts that are going out. Now, just to step back into that deductions, if there's agreed deductions, then those deductions will be on there too. Now, should leave balances be on payslips? Yes, of course they should be, but it is not necessary. So if you are seeking what your leave balances are and they're not represented on your payslip, it is not unlawful for your employer to do that. I just think they should be. So you can definitely ask. It is your right to ask about what sort of leave balances you've got left, and your employer should be able to provide you with an accurate number and your request for payslips. It is absolutely okay to ask for your payslips, especially if you're not receiving them regularly. And then it just talks about what happens if you don't receive a payslip. Okay, and there's some best practice tips. Issue payslips on easily printable format that makes sense, so the employees can access them, and they should be written in plain English. Yeah, your payslip should not be a mystery to you. There is some information on there that is complicated: HEX, staff, deductions, FBT, fringe benefit tax, what your superannuation contributions are. That's all actually really complex stuff to do with tax, and you might not understand it all, but it should also be quite clear to you what it is. Okay, hopefully that's of help to you. If you're having any issues with payslips, you're an employer that hasn't been handing them out, or you're getting it wrong, or you're an employer that hasn't been receiving them, or something's wrong with them, please give us a call. One of the more unusual things that we've noticed on payslips is the business entity and the ABN don't match. So that's actually a really unusual thing that happens, but it happens a couple of times a year for us that we notice. So if you are a business and you are making these payslips up, just make sure if you've changed your business name or you've updated your business entity, that you've also updated those payslips to make sense. We're going to be talking about employee grievances, disciplinary matters and internal investigations. Now, I'm not going to talk for a really long time on this matter. I could talk all day on this, but let's just get through some of the really high level stuff so we can get you thinking more about how to get it more right more often. How do employee grievances, disciplinary matters and internal investigations link? Well, that's kind of an easy one. Grievances lead to disciplinary matters, which, grievances lead to internal investigations, which lead to grievances lead to internal investigations, which lead to disciplinary matters. So of course they all link. So each step of that way, you need to get it more right more often. You need to document it. You need to have the right balance of independence and knowledge. You just need to really think about these things, because if your employee is going to start some sort of action against you, an unfair dismissal, general protections, discrimination, breach of contract, all the other things that they can do to you in relation to these, in relation to something that might end up in a disciplinary matter, then you need to make sure that you can protect yourself and show that you've done this investigation properly. What do I do if an employee has a grievance? Now, if you're a big company, you probably actually know the answer to that question. You follow the procedures, you get someone involved who knows more about it than you do, and you get it more right. If you're a small company and this is the first time someone's come to you with something that's actually a little bit unsavoury, you might want to stop and have a think about it, take a breath, stop and ask more questions with that person. Tell them that you need to go back and get some more information. Get the time that you need, and most of all, don't snap back an answer and say, I'll get back to you this afternoon on that, because you might find that you've dug yourself a very large hole that you're going to have to try and climb your way out of. So try to take a measured response. An employee has raised some serious allegations about sexual harassment in the workplace. What can we do to protect this employee until the conclusion is reached? Now, okay, there are two people involved in this, in my view. You've got the employee who's made the complaint, and you've got the employee that's been complained about. Now, obviously, at this very early stage, unless you actually witnessed it, you don't know the answer. You don't know who's right and you don't know who's wrong. Yeah. So first of all, you need to protect both of those employees. If they're working very closely together, figure a way to separate them so you're not treating the employee who made the complaint adversely, but also you're not having a predetermined outcome for the employee that got it wrong. One way of doing this is just standing down the employee that's under investigation while the employee that made the complaint can carry on with their job. There's a lot of other ways to do it. That's certainly not the only way, but certainly start thinking about it in those lines of thinking. Don't just keep them together and go, oh, well, they'll get along, don't worry. Once we figure this out, it'll all go back to right again, because it very rarely does. So you're protecting the employees also by maintaining their confidentiality. Make sure the support people that are coming in and having these meetings with the people you're talking to are independent enough and not going to be talking about this matter amongst other people in the business. Make sure that you've separated out the information, you've put up paper walls, or you've got an independent person coming and looking at it. And most of all, make sure you have an independence that makes sense. I have a lot of employees coming to complain to me about a disciplinary process or an investigation that's been investigated by the best friend of the person who made the complaint. Probably not a good idea. If it ever gets tested, you are going to get slammed. The other thing that you might need to think about is who's going to be undertaking that investigation. We can certainly help you undertake an investigation. You just have to remember, if we are part of the investigation, we cannot help you defend that investigation. So you could come to us. We might be able to get someone independent to come in and do the investigation, so we remain separate from it, so we can help you defend it later, or you might just want us to do the investigation itself. It's a matter for you, but we can certainly do both sides of that. But remember, if we do one, we can't do the other. An employee has falsely accused another employee. Do I need to still go through the standard procedures of investigation and discipline, or can I just terminate the employee for lying? Look, this goes back to the reasons for unfair dismissal matters. If you find that you've got an employee who's literally lied about someone else, started an investigation, or asked you to start an investigation which you know to be completely false, then you need to start disciplining that employee. Hopefully you've got a policy or procedure that relates to that. Otherwise, use the procedures and apply natural justice in this process. Ask them the question, listen to their responses, consider their responses, and then decide whether it's been serious enough under serious misconduct to terminate summarily. Now, if we go to serious misconduct in the Fair Work regulations, let me just open the book. It's pretty much around 1.07. Here we go. The meaning of serious misconduct includes willful and deliberate behaviour by an employee that is inconsistent with the continuation of the employment contract. Could fall there. Conduct that causes a serious and imminent risk to health and safety of a person, or reputation, viability and profitability of your business. Could be that. Conduct that is serious misconduct includes an employee includes each of the following. The employee in the course of the employment is engaging in theft, fraud or assault, has been intoxicated at work, or is refusing to carry out a lawful and reasonable direction. Now, these ones don't apply if the employee is able to show that in the circumstances the conduct engaged was not conduct that made the employment period of notice unreasonable. Now, that's a really interesting question that actually goes back to this original matter of summarily terminating without notice. Doesn't mean that you can just go, right, you're gone. It actually means that they don't get their pay in lieu of notice, or they don't get their notice period. So it's really actually not okay just to terminate someone for serious misconduct unless you've got some very, very obvious reasons to do it on the spot. Yeah, it is better for you to notify your employee that they've got it wrong. Ask them to respond to that, even if it's a show cause notice as to why they should be terminated, and ask for a response, because you should really deal with first notifying them of what they did wrong, asking them if they've got anything to say about it, and then genuinely considering that. So you really ought to still comply with that, except if it's a really serious issue, and without a shadow of doubt, it's going to be a no-brainer that person needs to be terminated. And that could be caught on video stealing or hitting someone, or it might not mean that. Okay, an employee has raised a complaint about another employee bullying her. Can I terminate that employee for making that complaint? It just means more work for me if I do not believe the person is actually being bullied. Yeah, look, I understand that. It always means more work. The fact is, you own a business. Part of that business is to comply with the Fair Work Act. The Fair Work Act basically says that you need to, give the employee a chance to respond to any issues that might end up in their termination. So you need to give them a chance to talk about it. The process of natural justice means that you need to at least investigate and consider whether it was true or not. Just because you think it's not true does not necessarily mean that it is not true. Look, Grievances, disciplinary matters, investigations, all kind of complex for you. They take up time, they take up money, they take up resources, and they take employees away from their jobs. And it changes the story, it moves the message often. So having a policy in place that you can follow when something happens is actually going to be easier for you. That'll make things a lot quicker, simpler, and it'll get better outcomes for you. So we recommend that first of all you think about what sort of policy you want to put in place for when a grievance occurs, and then just follow the story, take the stop points, make sure that you're following that process so it becomes easy, not hard. But yeah, I think you ought to take the time. It's part of doing business. You're going to have employees that are not happy, but it's pretty much your job to make sure that if you are terminating someone, it's for the right reasons. We can certainly help you. We can absolutely help you with the investigation. We can absolutely help you with the letters. We can absolutely help you with getting responses back from your employees. We can talk about the investigation. We can talk about the termination, and we can help you with all those things. So don't feel alone. It could be a big issue, but we can certainly help you make that a little bit easier and a little bit less complicated, and let's get some clarity into it. We're going to be talking about employment documents. Now, what is employment documents? Well, there are employment contracts, policies and procedures, confidentiality agreements, some sort of deed. It could be contractors' agreements in relation to the employment. It could be agreements to take long service leave early, or cashing out holiday pay, or personal leave. It could be some sort of agreement about going on a sabbatical or having a secondment. So employment documents essentially are everything that your employee will have and interact with you as an employer. What documents are important to get right? It's a really big question. Okay, so first of all, it's probably a good idea to get those employment contracts right. And if you don't have employment contracts, fine, but if you do have them, get them right. I can't tell you how many times an employer has called me and said, hey, look, this person's left without giving me any notice. Can I deduct the notice period off the salaries? Well, they haven't got an employment contract that says that sort of deduction is okay. No, not really. You can't deduct all of it, and only if you are going to deduct, only as far as the award or your enterprise agreement allows. Or an employer's called me up and they've said, I've just found out my employee is moonlighting somewhere. Surely that's a breach of the employment contract. Maybe, maybe not. Get that employment contract right first. Okay, another employment contract to get really right is some of those policies and procedures. Make sure they're up to date. Make sure they actually mean something to you and the business. Don't just have a policy for the sake of having a policy. Have a policy that means something, because once you've got a policy that means something, you can then filter that down and get it right from the very top right down to the very bottom. If you've got, for instance, a no smoking policy, and it says no smoking in the workplace, easy peasy. What about outside the workplace? Okay, no smoking within 5 meters of a workplace. Okay, well that's part of the law, but it's not necessarily in your policy. Oh, you might say no smoking in the workplace and you must comply with all laws. Well, what are those laws? So look, I think it's probably a good idea to get it really simple. Don't have policies that are cajillions of pages long. Make sure your employees are going to read them. Make sure you've got documentation that they've read them, and make them relevant. I think that's really important. Other employment documents to get right, payslips. Don't get those wrong. You have penalties attached to getting your payslips wrong. Don't do it. Make sure if you're going to get any written agreements about how people are cashing out their annual leave, get that right. Because if you don't get that right, you might find yourself being sued and having penalties attached. How do I know which employment documents I need? Well, I guess in many ways you've got to think about what your business is, what you want, and what you want your employees to know. So, for instance, you might want your employees to know that your confidential information is super important to you. So, have a confidentiality clause in your employment contract or a deed, confidentiality deed. It might be that what's really important to you is all your employees complying with social media requirements. Get a policy in place. Prescribe the social media requirements. Maybe it's really important for you that your employees dress in a particular way. Get that in a policy. That's an important document to you. It's not the same for every employer. So what's good for you is not good for me, it's not good for these guys. So stop and think about what you want to achieve, and get someone like us to help you build that strategy so you only need to have the documents that you need. And if there's a bit of gravy on top and you have a few documents that are great to have but not necessarily need to have, then there's no problem there, but at least you've got the ones you absolutely need. What we need to advise our employee some issues we've been noticing around the workplace. What letters should we present them regarding this? Okay, so when we're talking about issues around the workplace, we're probably talking about conduct or performance. Look, the first thing you need to do is you need to stop and think about what they're doing and what conduct and performance you need to tell them about. So get it really particularized. The next thing you need to do is notify them. Yes, you absolutely should be putting it together in a letter form as well as verbalization. I hear a lot of people telling me, oh look, I told my employee about 10 times that they needed to get it right. Did you ever tell them if they didn't, they would be terminated? Probably not such an easy thing to say. So we encourage to back everything up in writing. All lawyers want things in writing, and we're certainly no different, but you also should have it in writing too. Your employee cannot run from something that's in writing. So they can't say you never told them if you sent them a letter in writing about what happened. So yeah, absolutely. Make sure you understand exactly what's been going on, exactly what performance or conduct you want changed or altered or stopped, and that you put it into writing and you send them a letter. That might mean that you need to give them a meeting and hand it to them face to face. Depends on you, depends on your policy, depends on what you want to achieve, depends on how often it's happened, but certainly get into a letter. We need to terminate an employee. What do we need to include in the termination letter if we need to give them one at all? We always need to give a termination letter. It's actually a legal requirement in the Fair Work Act. Let me just find that quickly for you, Kat. Requirement for notice of termination or payment of lieu. An employer must not terminate an employee's employment unless the employer has given the employee written notice of the day of the termination, which cannot be before the day the notice is given. Okay, so yes, you absolutely have to terminate in writing. What do we need to include in the termination letter? Well, it depends on what's going on with the termination and how you've got around to terminating. For example, if you're terminating within a probationary period or within the first few weeks of employment, it's more likely than not you don't need a reason for termination. However, your employee is probably going to want one. If you're terminating because of conduct or because of some sort of performance issue, then I'm going to hope that that termination is not a surprise to that employee. You should probably contact us if you're going to terminate an employee without actually that employee realising that that's what might happen to them. The termination letter should probably have the reasons why you're terminating them if it's not under the probationary period. But really, you just have to keep it simple. Make sure that the employee knows they're terminated, make sure they know when that termination comes into effect, make sure they know that they're going to be paid certain monies at the time the termination is in effect, and wish them all the best. So, we would like to offer someone a position within our business without handing them an employment contract straight away. Is there a way we can do this? Yeah, look, there is. I think it's possible to give them a letter of offer telling them that the offer is subject to an employment contract which they will receive in due course. The trouble is, it depends how long you wait. If you wait for 2 days after employment starts, then the likelihood is your employee is going to sign that contract and not really care too much. If you wait to 2 years after they start employment, the likelihood is they're not going to want to sign that employment contract, and they have no way to force them to. So, look, I don't think it's an ideal situation. Legally, the preference would be to get them to sign an employment contract before they start. But there are situations where, for instance, you might be a business that's growing really quickly and you haven't got any employment contracts and no time to stop and think about it, and before you know it, you've got 5 or 6 or 10 or 20 employees and none of them have employment contracts and you want them. I think there's a soft glove approach here. You've got to stop and discuss this with your employees, let them know that you're going to start getting employment contracts put together, that it's more likely than not going to change any of their working conditions, but to take a look at that contract, and if they're comfortable, please sign. So yeah, I think if you're going to get them to sign a contract after they've started work, I would think very carefully about the process you're going to take in order to get that signature. We're going to be talking about preparing and appearing in courts, tribunals and commissions. So what are employment commissions, tribunals, courts? Well, look, there's a pile of them, but among others, there's the Fair Work Commission, there's the Queensland Human Rights Commission, the Queensland Industrial Relations Commission, we have the Civil and Administrative Tribunal, and we've got the Office of Industrial Relations, we've got Commonwealth Courts, we've got the Federal Circuit Court, we've got the Federal Courts, we've got the Magistrates Court, we've got the District Court, we've got the Queensland Courts here, so we've got the Supreme Courts, and they are state courts. So there's a lot of different places that you might find yourself as an employer. You might find yourself in the Queensland Human Rights Commission, and you might ultimately end up in the QIRC, the Queensland Industrial Relations Commission, or you might find yourself in the Fair Work Commission and then ultimately find yourself in the federal courts. It does depend on the matter. For instance, for most general protection matters, they start in the Federal Fair Work Commission and they end in the Federal Circuit Court. For most discrimination matters here in Queensland, they start at the Queensland Human Rights Commission, but they end up at the Queensland Industrial Relations Commission. So it does depend very heavily on where you are and what you're doing. Now, an employer's made a claim against me. Can I just ignore it? Well, you can. It's not a good idea, but it's certainly an option. If you ignore the matter will more than likely be found in not in your favour, and the penalties will be far higher for you. So we do not recommend that you ignore any claim. If you have a claim against you, it's more than likely you've been served it, so it's an official thing, and there's more than likely a way, some information in that claim about how to respond. So go ahead and start thinking about putting that response together. I know all lawyers say that you need to get legal assistance in this, and we are certainly no different. If you're going to have a claim against you, make sure you give a lawyer a call. We can certainly help you with that. Make sure you get somebody who's experienced in that space, because it can be more expensive if they're not. And if you've got the capacity, we would certainly recommend that you get your solicitor to get barrister assistance as well. It's only because barristers tend to assist us in the actual hearing stage, and if they've been a part of the process throughout the time, it's going to be easier and cheaper for you to get that barrister to do that advocacy in the court or in the tribunal or in the commission on our behalf. Now, we do all the other work, obviously. We do a lot of the legwork, the negotiations, the discussions, the prepping of documents, and so on and so forth. And there is a lot of those. Depending on which tribunal, commission or court you're in, there are different rules surrounding that. For instance, if you're in the Federal Circuit Court, you comply with the Federal Circuit Court rules. If you're in a state court here in Queensland, you've got the UCPR, the Union for Civil Procedure rules. If you're at Queensland Industrial Relations Commission, you've got the Queensland Industrial Relations Commission rules, or the Industrial Relations rules. If you're at the Fair Work Commission, you've got the Fair Work Commission rules. So there's a lot of rules and regulations around how to behave, the protocol, what to do, when to give evidence, how to give that evidence, so on. in each jurisdiction, and having a lawyer is going to actually really help cut through some of that noise. An employee has made a claim against, an employee has made a small claim against me. Can you represent me in that matter? Now, I'm going to assume for this question it's a small claim in the Federal Circuit Court, and it's more likely going to be an unpaid entitlement claim. Small claims in the Federal Circuit Court under the employment jurisdiction are an own cost, no lawyer jurisdiction. What that means is the employees, that means the parties basically bear their own costs no matter who wins and who loses. It also, the no lawyer jurisdiction means if you want a lawyer to appear on your behalf, you need to make an application to court to request that to happen. Now, obviously, lawyers like myself make that request on your behalf, but the other side can actually refuse, and that will cause more complications in getting an approval from the court, getting leave from the court to appear. So sometimes we can represent you, sometimes we can't. More often than not, we are able to help you in behind the scenes in the ghostwriting stages. We can help you prepare those documents, get ready for the actual appearance. We've been handling a Fair Work Commission matter on our own, but acknowledge that we are out of our depths. Is it too late to engage a lawyer for help? Look, actually, it's pretty much never too late to engage a lawyer. If you engage them very late in the process, it can cost more money than you've saved, because what we're going to have to do is read all the documents first, figure out what's been happening, and then provide you some advice, and then take some steps moving forward. So the later you get in that process, the more work we might have to do to kind of tidy it up a bit. We might need to amend your documents to make them better. We might need to get more affidavit material, more witness material. We might have to do more negotiations with the other side. So it can actually end up being a little more expensive having solicitors come in at the end than you would at the beginning. But it is absolutely a matter for you. From our point of view, until the judge or the commissioner or the tribunal has actually made a decision, you can always at least ask for representation, seek leave for it and get it, and have someone appear for you on your behalf. We can do that for you. There's no problem there. We can help you get that permission, and we can do the appearances on your behalf. You just need to contact us, and we can talk through where you are in the stages, how we can help you, and what the costs might be. We're going to be talking about policies and procedures, drafting them, us assisting with you in getting those done, or us reviewing them. What is a policy or procedure? Now, this is a document that is, I call them living documents. So as your business expands or gets more sophisticated or contracts, you're going to need different policies and procedures in relation to this. You're not going to need a policy about working from home if there's two of you working in the office. You're probably going to need a policy about travel in the workplace if you've just hired 5 traveling sales personnel. Yeah, so it does depend on what you're doing and how big you are or what you need. But normally it's a living document that works with you and your business. It is not something that is incorporated into your employment contract, and I cannot stress that enough. But a lot of people say, oh, can't I just have that in an employment contract? Well, let's talk about a policy that might not make any sense at all in an employment contract. For instance, you might have in your employment contract that your employees need to not breach the IT policy, or they must use the internet in accordance with the IT policy. Now, if you prescribe what that IT policy was in the employment contract, and technology changes, the internet moves on, there are different ways that people can enter into your business by reading emails and having fake accounts, and you didn't put that into the employment contract, then your employee doesn't necessarily need to comply with that requirement. But if you tell them they need to comply with the internet policy, and that policy changes as technology changes, then they have to comply with those changes as they go on. So there are things that you put in an employment contract and things that you specifically leave out and put into policies. It's a bit of a murky area in some ways. If you don't know the difference, and you think it's important for your business, certainly give us a call. We can absolutely help you nut out what the rights and wrongs are on that. One of the benefits of having these policies reviewed and drafted by MJT Law. Well, we know all about them, which helps. We also know about other people's businesses. So we can give you more information about another policy that you haven't thought of. Or we can look at your policy in one way and know from our experience that perhaps it would be better if it looked like this. So, more minds on the matter will actually create a better result. So that's one reason why using MJT Law is a really good idea. The other way is, at least you know that your policies comply with the legal requirements. There are policies out there that just don't make any sense. They've been pulled off the internet, drafted from American perspective, and just don't make any sense here. And if you have a policy that doesn't make any sense, how are you going to ask your employees to comply with it? I have one policy that encompasses a variety of topics. Is it best to separate them out, or can I keep them as one document? It's a really interesting question. I have a lot of employers who have one giant document that's basically, the employee handbook, for instance. Is that a good thing? Well, I guess it doesn't matter, but I'm always really wary about these giant documents that encompass all the policies and how much the employee is actually reading. For instance, if you've got a document that's 60 pages long, when was the last time you read all the way through it? However, if you have a policy that's 2 pages long, but you've got 10 of them, or you've got 30 of them, then it's more likely than not, at some point you're going to wade through them all. I'm just mindful that they might flip through the front, flip through the back, but not look in the middle. And if they're signing a document saying that they've read the policies, and they really actually haven't, look, it's not great. So I think it depends on the business, and I think it depends on what you're trying to achieve by this handbook, and I think it depends on how you are making sure your employees are reading it. I have had the same policy for 5 years. Is it time to change it? I have no idea. It depends on the policy. For instance, you might have a clothing policy that states all employees must wear suits. That probably doesn't need to be changed in 5 years. If you've got a business that everyone wears suits, then they're going to continue wearing suits in 5 years' time. But if you have a policy that states, for instance, everybody must use Yahoo search engine, and in 5 years' time Yahoo is bought out by Google and it's no longer called Yahoo, how are they going to comply with that policy? So I think it really does depend on the policy. It also depends on the law. 10 years ago we didn't have the rules around smoking that we have now, so the policy back then wouldn't necessarily give you the same quality and protection under the Work Health and Safety Act as it would 10 years ago. Or you might have something that's come up and it actually needs a policy of its own, and it's all encompassed into one. Like you might have a policy that just talks about PPE, and actually you've got a business that deals with engineered stone. So in fact, that PPE, I think it's probably a good idea to have a specific policy for those workers who are working in and around that engineered stone, for its own protection. So it does actually depend, I think, on the sort of policy, the sort of business you've got, and actually what's happening out there in the industry and work health and safety and employment law and all of that. I guess the answer is it's complicated. It's always been complicated. Do I need to have policies, or can I capture all the information in the employment contract? Now, we've talked a little bit about this a little bit earlier on. It's not a good idea to put all your policies into your employment contract for all the reasons I talked about. Also, I don't think it's also a good idea to have one giant policy, because I don't think people are going to read it. But it's certainly important for you to think about how you're going to incorporate those policies into your employment contract. Now, we can help you with all of this. We can help you draft the policies, identify the policies that are right for you. We can help you update your policies, and we can certainly help you implement it into your employment agreements and make sure that you've got the right processes in place so you are ensuring that your employees read those policies. We're going to be talking about restraint of trade and confidential information. The first thing we need to think about is, what is a restraint of trade? Restraint of trade is a restrictive covenant that restricts your employees from doing something later, or of course now in the employment contract. For instance, you might restrict them from moonlighting with a competitor, or you might restrict them from actually going and working for another competitor. You might restrict them from encouraging your employees to leave your business, or you might restrict them from openly talking to your stakeholders. So there's lots of things, and you can restrict them for, employees want to have no restrictions at all. Employers want to restrict for the universe for an infinite amount of time. So there's always going to be conflict. The other thing to think about is confidential information. Now, in my view, these go hand in hand. Two really complex areas of employment law, and in some senses quite different, but they work often in unison. So you might have an employee that has a restraint of trade, which really isn't very enforceable, but they've done something that's breached confidentiality, so that's what you're going to catch them out on. So confidential information is where your employee has got access to information that's not in the public environment that you don't want them to use elsewhere, and perhaps they may have done so. So we need to think about how to protect your interests there as well as your interests in restraint of trade. Is it unreasonable to extend my employee's restraint of trade to an entire state? Look, it depends on what you do. If you are a hole-in-the-wall cafe owner, then it's probably going to be unreasonable to tell your employees that they're restrained from working in a cafe in Queensland or in New South Wales or in South Australia, for example. But you might be reasonable to say you can't work within a kilometre vicinity radius. So it does depend. You might be a multinational business, so you're all over the country. Your employees been working primarily in the Queensland region, and you don't actually care if they go out to New South Wales because they actually don't know any of your clients out there or who they are, so just good luck to them, but you're going to restrict them for Queensland, and that makes a lot of sense as well. So it does depend quite heavily on what is it that you do. I do not have a restraint of trade clause in any of my employment contracts. How can I bring one into effect without amending and rescinding all employees' an employment contract? It's going to be really tricky for you to do that. Restraints of trade, in my view, are material changes in your employment, in your working conditions. So basically the law states that your employee doesn't have to agree to material changes in the working conditions, and it also goes further and says you must get written permission from your employee to make those material changes. So look, if you don't want to change your employment contract as a whole, I can understand that. If you want to add in a restraint of trade into their employment conditions, you're going to need to get it in writing, and you're going to need to get them to sign it. If they're refusing to do so, there's not much you can do lawfully. We can talk about negotiations, and we could talk about reasonability, and we can try and assist your employee to come to the decision that they should be signing that agreement, and we can probably give them some incentives to do that. But you cannot adversely treat them while they're exercising a workplace right. This is basically a breach of their general protections. So be very careful about how you're interacting with your employee and whether you are threatening them for some reason and making them feel fearful for their job, because that might be a general protections matter. But certainly you can amend the employment contract without changing the whole thing. You would just write a letter telling them that you wish to insert X clause into their employment conditions, and will they approve it. Aside from poaching clients, can I restrict an employee? What can I restrict an employee from doing? Well, there's a load of things you can restrict your employees from doing. You can restrict them from discouraging other employees to leave, like I said earlier, from using your suppliers and such things.
but it's often a really good idea to be really industry specific about this. If you want that restraint of trade to stick and you want to be able to sue on it later, then make it specific to the actual job that person is doing. You don't have to make it specific to the actual individual, but the individual's job. And that will make a lot more sense to the courts, and it will give you much more scope to reduce that clause into what you want them to not do or what you prevent them from doing. So if you have to put an injunction in later because they've got up to mischief, it's going to be so much easier for you to do that. Now, you need to understand that restraints of trade and confidentiality agreements are the most, in my view, complex areas of employment law. There's a lot of things that go into it. We talk about public policy, we talk about construction of the documents themselves, we talk about implied conditions, we talk about good faith, we talk about goodwill. We talk about all sorts of things in these, and it really makes a difference on how they're drafted and for what purpose they're for. To have a restraint of trade that actually is, you can argue in a court, you need to make sure that you understand what the person was doing before they left, you understand what they were doing as they were leaving, and you need to understand what they're doing now. So we can really narrow down the breach and get that injunction in place and get that restraint of trade over the line.
Hi, my name is Melanie Thorley and this is MJT Law, and today we're going to talk about the Small Business Fair Dismissal Code. To do that, I'm just going to jump onto Google. I'm going to Google Small Business Fair Dismissal Code. Wow, that didn't help at all. Sorry about that, guys. I'll write it out. Looks like it's actually found it. So you find this on the Fair Work Commission website, and it just goes through the process. So what we're going to do is what it does, Small Business Fair Dismissal Code is designed for employers who are a small business. Now that is a small business as defined under the Fair Work Act is a business that has less than 15 employees. So that's 14 employees or less. Now, there are a number of things that an employer who is a small business can be exempt from. One of them is paying out redundancy pay, and another one is, it says in the unfair dismissal regime, if the business is a small business and it is complied with the code, then it is not an unfair dismissal. So that's something to think about if you are a business and you want to comply with the code and you want to dismiss someone, and as an employee who's been dismissed from a small business. So what we're going to do, just to assist, is we're going to bring up the small business checklist. This is a document called about the Small Business Fair Dismissal Code. And again, it says here fewer than 15 employees, and a small business employee cannot make a claim for unfair dismissal in the first 12 months of their engagement. And that means that if you've been employed for 12 months, less than 12 months, then you are not eligible as an employee to file an unfair dismissal application. But this code just helps small businesses get it right more often. Yeah, it talks about it is fair for an employer to dismiss an employee without notice or warning when the employer believes on reasonable grounds that the employer's conduct is sufficiently serious to justify immediate dismissal. Now that's got to be quite serious, and they've said serious misconduct includes theft, fraud, violence, and serious breaches of the occupational health and safety procedures. Look, it's quite rare that it's serious enough for immediate dismissal, but just remember that there are some things there on the list that could mean that. Now, the Small Business Fair Dismissal Code checklist is actually quite comprehensive. It goes through from start to finish how to comply with the code. Are you a small business? How long has the employee been employed for? Did you dismiss the employee because the job wasn't required to be done by anyone? Now that's technically a redundancy, and then it says, if yes, did you comply with the requirements to consult with redundancy? So it's really just a step-through process to help employers get it more right more often. And now it talks about dismissal, about misconduct, and it just goes through some of the things here. So if you find, and there's a declaration at the bottom, so if you're an employer who wishes to dismiss an employee, we recommend that you download this form, you follow it, tick it off, sign it and date it. So you've got to put it on the record of the employee once, on the employee's record. So if required, you can bring that up later and say that I complied with the code. Now, compliance with the code is obviously more complicated than that, but at least you're getting it more right more often. And as an employee, it might be a good idea if you are an employee of a small business, just to keep this in your back pocket, just to make sure that they have done it right, just to make sure that all the steps, all the reasonable and probable steps have been taken if you are being dismissed. If you have any questions about being dismissed, or you have any questions about dismissing an employee, let me know. We can help you there. Thank you. Hopefully this has been of help to you today. Remember, the Small Business Fair Dismissal Code is found at the Fair Work Commission. And we found it just by Googling Small Business Fair Dismissal Code, but you could just as easily go into the Fair Work Commission's website and download it from there. Hope this has been help, and thank you for watching.